prohibition of Benami Transaction Act nowadays is in full discussion because of the judgment that has been given by Honorable Supreme Court of India. However, we need to note that the Rajasthan High Court in Niharika Jain versus Commissioner of Income Tax case, which was a single bench decision, and the division bench decision of the Kolkata High Court in the case of Ganpati Dealcom Private Limited versus Commissioner of Income Tax. Both these high courts are unanimous in interpreting that the provisions laid down in Benami Transactions Act in Section 3.2 as well as Section 5 are very harsh, and you cannot induct a imprisonment or a punishment from retrospective date. In the light of these two decisions, Government of India prepared an appeal with the Supreme Court to make these two decisions null and void. However, the Supreme Court, under the chairmanship of the Chief Justice of India, a bench of 3 judges, has struck down those particular two sections, Section 3.2 and Section 5 of the Benami Transactions Act. Now, under this particular law, it has been pinpointed that in the Act of 1988, the definition that was being given of the Benami transaction and the interpretation that has been made by the Supreme Court of India is quite a bit different. The Supreme Court has observed that the definition of the Benami transaction is comparatively defective because it not only includes irregular transactions, illegal transactions, but it also covers up some legal transactions. So modification of the definition is being required. For example, they cited out that if a person purchases certain property in the name of son's wife and consideration is paid by his friend, and the concerned person pays gift tax on that, though this is a legal transaction, yet it will be covered under the Benami Transaction Act. So in the light of that, the government felt that this is only a clarification of 1980 Act, and there is no need for considering this particular entire section as invalid or which can be considered as ineffective so far as the matter of law is concerned. But the Supreme Court finally decided that Section 3.2 is very harsh, it is arbitrary and needs to be struck down. So accordingly, they have pointed out that the defective definition of Benami transaction in the Act of 1988, so was the case in the Act of 2016, is not valid because it covers up some items which are also to be considered as legal transactions. Court also observed that the way in which this particular transaction is being treated as criminal transaction, that also is absurd, and you cannot give a retrospective amendment or retrospective effect for such offense in itself. In order to constitute a particular act as a criminal act, there has to have a presence of or element of mens rea that is totally absent in Section 3, and as a result of which this particular act cannot be called as a criminal act, and hence all those initiation of offences which have been initiated under this particular law prior to 1st of November 2016 are ineffective. No punishment can be inflicted on all those beneficial owners and Benamidars are concerned. So that was the first issue that the Supreme Court laid down. Then the second important point the Supreme Court observed was that you cannot confiscate any property which is violative of Article 20 of the Constitution of India in itself, and as a result of which the confiscation of the property that has been made needs to be released in itself. In Pune, you perhaps might be knowing that the Department of Income Tax, who is handling this particular department, has initiated so many notices to the common taxpayers in itself involved in Benami transaction, and accordingly have seized property, confiscated property in the form of bungalows, in the form of cars, in the form of karyalayas, offices, etc. Even the land is also been confiscated and seized. So in these particular cases now, all these items which have been seized, confiscated, will have to be returned to the concerned either beneficial owner or benamidars are concerned. This does not mean that entire thing is being taken out from the hands of the department. They can levy penalty, so only the civil nature of this particular law will remain in force. The criminal nature of the law perhaps will go away by the judgment that has been given in Ganpati Dilcom Private Limited's case. This is a historic case which we need to remember, because this will be giving a way to understand how the law should be and how the law can become in the times to come in itself. So on these two counts now, the benamidars and beneficial owners can have a sound sleep so far as the matter is concerned. Thank you for watching. If you like this video, please subscribe to my channel. Thank you.